Good afternoon. My name is Kevin Ellis. I am the local president of 2338 at the John J. Pershing VA Medical Center in Poplar Bluff, Missouri. I'm making this video because I want to help VA employees across the country understand what it is to have a whistleblower complaint and how whistleblower retaliation happens. Um, it's very important in order for good government to work. Uh, it is important that employees across the country have a avenue in which to speak to and address um, issues that agencies may not like, but are violations of law, rule, regulation, safety violation. They should have a safe avenue and a just culture to bring them issues forward without facing retaliation from your employer. So I'm going to talk about that today. I'm going to give you some real live examples of what disclosures look like, who they can be made to, who is involved in the process, and then how a decision is made. Okay. And I believe that what I'm going to share with you is probably going to be eye-opening and alarming because it blew my mind when I learned the um, the gravity of the cover up and the lack of accountability from not only VA officials within the federal government, but also Office of General Counsel officials and officials at the Office of Accountability and Whistleblower Protection. So we're gonna dive right in here. It is a Saturday afternoon. I believe it is February the 1st. We're gonna jump right in, okay? All right. The purpose of me making this video for you today is I want to demonstrate to you how OAWP has failed and continue to fail to properly investigate and continue to fail to properly hold VA officials accountable. Uh, Officials such as senior executive staff. That would be people like your medical center director, your associate director. Some of you may have associate director of patient care services. Some of you may have a chief of staff. These are called SCS employees. There are also employees that will be involved that are involved at your vision level. In my area, it's going to be Vision 15. Your area may be Vision 1, it may be Vision 2, it may be Vision 8, it may be Vision 9, 21, 20, whatever it is. The VA is divided up into visions, which are called Veterans Integrated Service Network, or regions, if you would think about it from a private sector term. It would be a regional office, okay? Uh, and these employees, when we often make a protected disclosure, they are just that. They are protected disclosures that should fall and do fall within the realm of OAWP to investigate to determine whether or not agency officials retaliated against an employee for making a protected disclosure. Now, the next thing I want to talk to you about is what qualifies as a disclosure. When an employee makes a report involving a violation of a rule, a law, a regulation, a VA directive, VA handbook, a law such as the Reasonable Accommodation Act, fraud, waste, abuse, failure to act, acting inappropriately, misconduct. This is all qualified as something to be reported as a protected disclosure. And that list that I just gave you is not all inclusive. That is only a part or a portion of what can be disclosed. Now, the next thing that I want to cover with you is how does VA officials engage in whistleblower retaliation, okay, or retaliation in general? They do it through a various ways, some of them very subtle, that you have to really dig in to determine that they retaliated against a whistleblower. You have to dig into some of them. But some of them will be such things as lying under oath. Some things would be, some of them could be, retaliation would be violations of the merit promotion system, refusing to promote an employee because an employee is engaged in protected activity, or because an employee has failing to promote them because they made a protected disclosure. Sometimes they will detail an employee because they made protected disclosures. They may downgrade their performance appraisals. For example, if an employee has been getting excellent and outstanding performance appraisals for the past 3, 4, 5 years, they made a disclosure against the manager, and then all of a sudden, out of nowhere, they're downgraded from an outstanding to a fully successful, or an outstanding to a fully successful, or excellent to a fully successful. So there's ways that they do it through promotions. They sometimes can do it in reduction of pay. Uh, because sometimes the performance awards comes with pay. So reducing the bonuses, reducing the opportunities to receive bonuses, reducing or removing the opportunities to maintain the outstanding. So there are very different ways that they do it. Another way could be counting the employee AWOL, counting the employee leave without pay, changing in duty assignments. For example, if an employee has been working by a window for the past 5 to 10 years, because they're the most senior employee and they've always had that window, removing that employee from that work location away from the window and putting him in the back of the corner, or putting him by an air conditioning event that makes them get sick all the time. So there are very many ways agencies will retaliate against you as an employee. I mean, as a whistleblower. Okay, so there is no uh, right way or wrong way. It's something that they would just end up doing. Okay. Another way they do it is they retaliate through disciplinary action. If all of a sudden you've got an admonishment for something that you've never ever gotten an admonishment for before, and other employees has performed in the same way, and they would never given an admonishment, that's retaliation. If they give you a reprimand for something that you've never been reprimanded before, and no other employee has been reprimanded for that, but you were, then that's going to be retaliation. If they've given you a 5 or a 10 or 30-day suspension for something that employees have not been given a suspension for in the past, then that is going to be retaliation. So the agency will often use disciplinary actions as a way to retaliate against an employee by trying to build a disciplinary history against them in an effort to terminate their employment. They may start with an admonishment, and then go to a reprimand, and then go to a short-term suspension, and then a long-term suspension within a relatively short amount of time. If you're an employee and you've experienced an admonishment and a reprimand and a suspension, short-term or long-term, within a 6 to 7 month period, more likely than not, you have been retaliated against. So these are the things that agencies would do when they engage in retaliation. Okay. Now, the next question I'm going to answer for you is, who engages in whistleblower retaliation? Whistleblower retaliation can be engaged in, or will be engaged in, from your frontline supervisor all the way to your vision director. They would be in. It will come from members of Vision 15, human resources specialist, or a human resources supervisor, or a Vision 15 human resources manager. In Vision 15, those people would have been Patrick Shea, human resources officer, his assistant, Abner Martinez, one of his employees, Jennifer Jenkins. Another one of his employees would have been Christopher Sherman. Uh, Vision directors, Patricia Hall. There are other people within Vision 15 who has the ability to impose disciplinary action upon you, or influence a local manager or a local quad member to engage in the same type of behavior. Engaging in whistleblower retaliation could also be members of the general counsel. In the Midwest, that would be employees such as Attorney Aaron Milligan, attorney Dane Roper, these types of employees and general counsel's office could engage into whistleblower retaliation. It's very, very possible. Okay. So you also have people locally in human resources could also engage in retaliation. It could be your privacy officer. At one point, we had a privacy officer at our hospital by the name of Lisa Edwards. She's still the privacy officer. Uh, uh, I made a protected disclosure to the news media. The news media turned around and tried to twist the protected disclosure I made involving a employee being hurt, trying to claim that a HIPAA violation had occurred, uh, which had not occurred. But how the privacy officer engaged in retaliation was uh, she opened a complaint and refused to do an investigation. She said, I did not investigate the claim because it was open and shut. It was a clear case of a HIPAA violation. But in reality, it was not. Just mentioning an employee's name and what their injury was, such as the employee, remember mentioning the employee got hurt lifting a patient. I gave the employee's first name, and for some reason, the Lisa Edwards deemed that to be a privacy violation. It was not a privacy violation. It was not a HIPAA violation. It was no violation of all. But she said I held the whistleblower uh, guilty or liable for a privacy violation, and there was no need to do an investigation. And she also said because human resources also told her to, and then gave that information to the agency to help propose termination. So even people within your agency can engage in retaliation. We have had EEO managers testify on behalf of the agency against a whistleblower or against an employee. So it does not have to be a manager in your chain of command. It could be other people that are appointed and accepted by the agency to speak on their behalf. So there are very different type of people who could actually engage in retaliation. Okay. Now, the next thing I'm going to cover with you is to whom are disclosures made? They can be made to your frontline supervisor, your second line supervisor, your third line supervisor, which could be the associate director, the chief of staff, the Associate Director of Patient Care Services. A disclosure can be made to members of Vision 15 headquarters, the Vision Director, Human Resources Manager, Human Resources Assistant, Employee Labor Relations Specialist. They can be made to members of Congress. They can be made to the news media. They can also be made to the Office of Accountability and Whistleblower Protection. And they can be made to the Office of Special Counsel. The OSHA is another government agency in which they can be made to. So the notion that a protected disclosure can only be made to a government entity that has the ability to offer a remedy is 100% false. Just 100% wrong. If you go back and you review the whistleblower training that all of us take within our facilities and the No Fear Act training, it will tell you in there very clearly that once a supervisor has been made known that a violation has been made against them for a violation of law, rule, regulation, or whatever it may be, that disclosure to their as low as their frontline supervisor is now a protected disclosure. Okay, so that's who all can in which disclosures can be made to. Now, how are disclosures typically made? I tell employees if you're going to make a disclosure, keep it simple. Use a simple email. Just take a simple email, send an email to them to the manager or supervisor or individual in whom you're making the disclosure to. They're copied on the email. That means they have full knowledge that a disclosure is being made and it has been made. It shows who it came from, it shows who it went to, and it also demonstrates what the disclosure is. Okay. So we're going to get into some of that here in just a moment. I'm going to walk you through a set of emails that demonstrate what is a protected disclosure. I'm going to walk you through some emails. I'm going to show you who was involved from the Office of Accountability and Whistleblower Protection. I'm going to walk you through some emails of who was involved from the local facilities. And I'm also going to let you hear a video by the Director of Office of Accountability and Whistleblower Protection himself, Eric Calhoun. So when I get done with this section here in a moment, it's going to be clear to you how to make a disclosure, who has been made to, who's held accountable, and then what the process looks like, okay? Without any further ado, let's jump in and let's begin, okay? All right, let me bring my screen up here. All right, so what you see in front of you right now is the first disclosure that was made. Let me get here. I'm not there yet. Give me just a moment. Oh, here's number one. All right. This disclosure was made initially on March the 16th, 2018. This is an example of what a disclosure will look like. It's coming from the employee, Kevin Ellis, and it's being made to frontline supervisor, Dale Garrett. It's being made to Patricia Tenhoff, medical center director. It's been made to a news media, KFVS 12. It's been made to the House of Representatives staffer, which is Jason Smith at the time, Debbie Griffin. And it was also made to a staffer at Senator McCaskill's office, whose name was Christy Mercer. And these involved an employee stealing a drug screen, a veteran's drug screen, sifting through medical records, and committing numerous HIPAA violations in order to give a drug screen to her niece to gain narcotics on the street because she wasn't using the narcotics. She was simply wanting to get her hands on them. This disclosure was made. The very disclosure you're looking at right now was placed into a proposed termination and issued to me by Robert Ritter. But the information was gathered by Patricia Hall. It was gathered by Dale Garrett. It was gathered by other members of Human Resources, Denise Smith, Joshua Holland, Daniel Carr. It involved Patrick Shea. It also involved William Patterson. It involved a whole host of people that actually engaged in whistleblower retaliation because they all gathered the information, submitted the information, and then proposed it to me. This exact disclosure was issued to me as part of a proposal to terminate my employment. Okay, that made it a protected disclosure, and at the moment they issued it back to me in a proposal to terminate, that made that a whistleblower retaliation. Full stop. Okay, I'm going to go to exhibit number 2 that I'm going to show you. Number 2 here is another example of what a disclosure is. I'm reporting here to the Secretary of the VA, Dennis McDonough. I'm reporting it to House Veteran Affairs, or House Majority, and the member of Congress. The disclosure is also going to Michael Missile, who was the VA's Office of Inspector General head, or the chief, but also copied my supervisor on the email, Dale Garrett, and also my temporary supervisor at the time in February 2021, Rita Clay Smith. So the disclosure was made, and I was complaining that the agency had violated 5 USC 2302 by engaging in a protected and by engaging in retaliation. Okay, that was a disclosure. Even if the agency said it was not a disclosure, even if it is perceived to be a disclosure, that makes it a disclosure. Okay, so let's go to the next exhibit here, and give me just a moment because I'm not quite sure how I got from exhibit number 1 over here all the way over to, all right, here we go. Here's number 3. Here's exhibit number 3 I'm going to show you. Here's another example of a protected disclosure. This time I'm complaining that there is malfeasance occurring on behalf of Human Resources employees and Brenda Norton, the laboratory manager. And the disclosure was being made to Pamela Hoffman, Human Resources, Charles Peterman, Human Resources Manager, Kimberly Atkins, Associate Director, VA OIG, Michael Missile, VA Accountability Team, the Office of Accountability and Whistleblower Protection is an email. Dennis McDonough, Secretary of the VA. I'm also complaining about Michelle Brightwell. She's part of the disclosure. Now, I want to show you something about that VA Accountability Team at va.gov. We used to receive names of individuals who we made a report to. At some point, they changed it to a VA Accountability Team. They will probably tell you so that everybody could get the email, but we don't know whether everybody gets it or not. But we used to have specific names in which we would make a disclosure to within the VA accountability team. Okay. Now, what's also important is the date. Just provides a date in which the disclosure was made. And the body of the email, which I'm not going to get into, will talk about what the complaint is about. This one happened to do with the agencies submitting false information to the Department of Labor in order to submarine Mr. Scotty White's workers' compensation claim. This was substantiated. It was proven that the agency did indeed submit false information to OAWP to workers' comp in order to submarine the employee's claim. This complaint or disclosure was actually verified by the Office of Accountability and Whistleblower Protection early on in 2020. I think it was 2021. Okay. So once again, this is another example of what a disclosure will look like. All right. Let's go to number 4. Number 4 is once again a example of a protected disclosure. It's going to Dennis McDonough, Secretary of the VA Accountability Team, which I'm sure is Eric Calhoun, Michael Missile, the head of the VA OIG, and then some other AFGE members, and also to include the House Veteran Affairs majority again. And the complaint is the agency is violating, they are performing improper or lack of investigations, and they're not holding agency officials accountable for acts in which they are involved in. That constitutes a protected disclosure, okay? Let's go to the number 5. This is another example of a protected disclosure. It shows who it's from, who it is made to. Once again, it's made to VA Accountability Team, which is OAWP. It's being made to Michael Missile, the VA OIG. It's being made to Dennis McDonough, Secretary of the VA. And the complaint is the agency is engaging in abuses of authority and prohibited personnel practices. This disclosure was made on July the 15th of 2021. And then it mentions the names of them and people that was involved in what I believe was involved in the abusive authority and the prohibited personnel practices, which included my first line supervisor, my second line supervisor, Jane Roper from the Office of General Counsel, Charles Peterman. So there's a number of people mentioned here in which the disclosure is naming or involved in engaging in whistleblower retaliation. Okay. Now, once you make a report to the Office of Accountability and Whistleblower Protection, or OAWP, it is then assigned to someone to perform a quote unquote investigation. We're going to look at it here. We're going to go straight to the exhibit number 6. And this particular one was a conversation between myself and Ryan Taylor. Let's go to the bottom of the email. Hold on to your eyes for a moment. The first email was sent from Ryan Taylor to myself on or about April the 15th of 2022. It tells me what the number of the disclosure is going to be. 22 Poplar Bluff 18872. It tells who the report is being made against, voluntary services, Dale Garrett. And here he says, for some reason, that it's outside of OAWP's purview and that the matter is being disclosed. It's been referred to Business 15. That is a very, very, very bad sign. Anytime OAWP takes a complaint from a local facility and refer it to a regional or a vision office just above the agency, that is a very, very bad sign. You have now just invited biasm and conflicts of interest into a investigation that should be occurring on that should be unbiased, and there should not be any conflicts of interest. When a vision gets involved in conducting an investigation, the individual that's here that was investigated was Dale Garrett. Dale Garrett worked in connection with the same people who the disclosure was made to at Vision 15. He worked with uh, Patrick Shea. He worked with Abner Martinez. He worked with Jennifer Jenkins at the Vision 15 level. So why would OAWP refer an allegation of whistleblower retaliation to the same people who were involved in committing the whistleblower retaliation? That is a huge, huge conflict of interest. Okay. Now I'm going to get to some more exhibits here. Let me close out number 3. Let me close out number 4. Let me close out number 5. Okay. Because my screen just doesn't hold all of them. All right. Now we're going to move on from Ryan Taylor. Remember, Ryan Taylor was from the Office of Accountability and Whistleblower Protection. He was an intake and a referral analyst is what he was. Okay. Now, there was some complaints here because I expressed here there is a major concern that a whistleblower retaliation is being asked to review or get involved in the whistleblower retaliation at the local level. And I spelled out to them it is a violation of VHA Handbook and Directive 0700. It's a conflict of interest. Okay. With that being said, Mr. Ryan Taylor continued on. He didn't care. They didn't care at all. They moved forward, and there was no resolution. As a matter of fact, what Ryan Taylor did not do was they did not conduct an investigation. They never took a statement from me. He never talked to me on the telephone. I don't know whether Ryan is a male or a female. I don't know whether he's white, black. I have no idea who Ryan is other than seeing his name on the email. Ryan Taylor never interviewed me as part of 22 Poplar Bluff 18872. He never interviewed me, not one single time. Okay. Now, in the follow up, I'm going to go to exhibit number 7. This is a separate disclosure made to another OAWP investigator, to OAWP. Hold on to your eyes. That was assigned to Andre Tucker. Andre Tucker was with the VA's Office of Accountability and Whistleblower Protection. Mr. Tucker was engaged in one of my cases involving whistleblower retaliation. We communicated back and forth through email. We communicated back and forth through telephone calls. We communicated back and forth through, I sent him a video. And then for some reason, I could not get any answer or follow up to the complaint that I had made. That's why the email is labeled follow up on 15 decision. I'm trying to figure out what is a follow up to the complaint that I made involving the 15-day suspension that I was given. And for some reason, Mr. Tucker would not give me an answer. Ms. Tucker, his supervisor, Ms. Cravens, obviously was Mr. Tucker's supervisor, responded back to me, and still there was no resolution. She even said to me that I could reach out to OSC and ask him what protections they could provide to me. I did that, and OSC was no help either. I remember speaking to Sherry Schilling from OSC. I remember speaking to 2 or 3 other different attorneys at the Office of Special Counsel about my protected disclosures as a whistleblower. There was absolutely no resolution or protection from any of them, whether it was a 714 or a Chapter 75. I was afforded no protection as a whistleblower. And the same thing has been happening all over the country. This is my disclosures, and this is my engagement with OAWP and with OSC. But I'm only one of several thousand. Multiple employees have complained all over the country. They were involved, they were receiving the same type of lack of investigations and lack of communication, lack of transparency when they also filed OAWP complaints. Okay, let's go to exhibit number 8. Exhibit number 8 is information that I sent to Miss Jennifer Jenkins. These were the questions that she asked me in my initial interview. She captured the answers. I responded to her, what type of changes can I make, because some of it was inaccurate. She told me to go ahead and make some changes. Let's go to exhibit number 9. Here, the changes were made, and these changes were signed and dated on August 1st of 2022, and then emailed back to Miss Jennifer Jenkins. Here is an example of the conflict of interest. Earlier, I told you that Ryan Taylor and Andre Tucker had been farming out our whistleblower complaint allegations to local Vision 15 individuals. Jennifer Jenkins was one of the individuals who was working for Abner Martinez and Patrick Shea at the Vision 15 level that was actually involved in targeting my employment as well as other employees' employment at the local facility. There lies a conflict of interest, for one, and then two, it is a violation of VA's handbook 0700 and directive. Jennifer Jenkins should have never been involved, okay? At all, she should have not have been involved. Let's go to exhibit number 10 of 12. Exhibit number 10 of 12. Earlier, I mentioned to you that Ryan Taylor had been refusing to communicate with me. He refused to conduct the investigation. I reached out to his supervisor, Ms. Stewart, on a couple of different occasions to get a response back from her. I called and left the telephone. I called and left voicemail messages for Ms. Stewart. I called and left messages for Ryan Taylor. Ms. Stewart never responded back when I complained about what was occurring. Even though I was given her name by Ryan Taylor and included her on the email, she never responded back at all in reference to my whistleblower retaliation claim. Nothing at all. She never responded. Okay. That's exhibit number 11. I'm going to stop sharing just for a second here if I can figure out how to stop share. All right. I'm almost done. That was exhibit number 11. We're fixing to go to my next exhibit here, and I will be done. Give me just a second here to get this pulled back up. And we're going to pull up number 12, my last two exhibits. Okay. Let me come back to share. All right. Earlier, I told you there is a conflict of interest. As you look at the screen in front of you, every vision, whether Vision 1, Vision 2, Vision 3, all of them have what's known as a OAWP notification email group. That email group will consist of members who are part of the notification team. As you look at the list in front of you, you're going to see some names that I just complained about. Jennifer Jenkins, HR Specialist. Abner Martinez, Vision 15 Chief, Employee Labor Relations. Patrick Shea, Human Resources Officer. Christopher Sherman, HR Specialist, ERLR. these individuals, these very individuals, were already engaged in the whistleblower retaliation against whistleblowers within Division 15. OAWP notified them of the OAW of the complaints and allegations, and these individuals were involved in conducting investigations. A huge conflict of interest and a huge violation of VA Directive 0700 to have Jennifer Jenkins, Abner Martinez, Patrick Shea, and Christopher Sherman involved in any complaints of retaliation. Should never have occurred. Okay. Now, you may ask the question, well, how do you know these people did the reports? The reports that I filed, some of them, were taken by Jennifer Jenkins, Visit 15 ERLR. Here is a separate email, number 12, in which a local agency official by the name of Libby Johnson, who was an associate director at one point, verified on April 18th of 2024 that she finalized a report and sent the report back to OAWP herself. So this now tells me that not only is Vision 15 people engaged in drafting reports, but also local agency officials are engaged in drafting reports and being sent back. Okay, that is the type of emails that would demonstrate and show what a disclosure is, how it's made, who should be involved, what type of content should be involved, and then who would be likely be involved at the Vision 15 level and or your local facilities. Okay, I'm going to stop sharing here just for a moment on this exhibit, and we're going to move to a different exhibit, which I think is very important. I'll have to stop share first. Let's stop share. Then I'm going to share back up. All right. This is a video that I feel like it's important for you to hear and know about. And this is going to come from, this is OAWP training that was supplied here to us by OAWP. I'm going to disconnect my headset for a moment. I'm going to hit play. I'm going to allow you to listen to about 5 or 6 minutes of this conversation from Eric Calhoun. Okay.
Let me try to get this.
I can pull up the slides from my side if you want, see if you can see them.
Yeah, I mean, I can't get any of my controls to appear to even present. Do you have the slide presentation?
I do. Here, I'm pulling it up.
Cindy, and then I'll let you know when to advance each slide. And again, sorry for the difficulties. I don't know. I'm probably gonna have to reboot my computer. At any rate, my name is Eric Calhoun, and I'm the director of the Investigations Division at OAWP. And one of the things that I think is helpful in some of these presentations that I've been giving around the country is just a little bit of background about myself, just so that you can understand sort of my perspective on things and what I've experienced here at OAWP. I was brought into OAWP in October of 2019, and essentially I was brought in to fix some problems that OAWP was facing. Within 2 weeks of my arrival, the OIG report came out in OAWP that basically said we were investigating things that we should not be investigating. We were not investigating things that we should be investigating. And worst of all was that the IG found that our investigations were biased. Which from an investigative standpoint is about the worst thing you can hear. To compare it to a medical setting, it's sort of being told, in contrast to the Hippocratic Oath, that you're actually doing harm first thing when interacting with a patient. So that's sort of what I walked into here. But in terms of my background, I was a local law enforcement officer for 20 years plus before I entered federal service. And I began my federal service with the U.S. Department of Labor, investigating whistleblower retaliation claims in the private sector. After that, I went to the U.S. Office of Special Counsel, where I worked for about 10 years. OSC, if you're not familiar, investigates whistleblower retaliation allegations, prohibited personnel practices, and also enforces the Hatch Act across the Federal Service. After OSC, I became the special agent in charge of the Washington Field Office of the U.S. Citizenship and Immigration Services, which is part of Homeland Security. I next became the special agent in charge of the New York Field Office. And the last position I held with USCIS was the director of the Special Investigations Division. And there we investigated senior leader misconduct and also had a counterintelligence mission for those state actors and non-state actors that wanted to compromise our immigration system. So that's just a little bit about my background. And again, when I came to OAWP, we had a 572 case backlog. I'll give you some context for that later in the presentation as I go over our numbers. But there were some challenges, certainly, when I first got here. In terms of the presentation, I welcome any questions at any time, with just a couple of caveats. One is we can't address specific issues because if we get into specific issues, there are real restrictions related to privacy issues that would prevent us from having a meaningful discussion. We would basically have to cut it off. So, but we can certainly speak in generalities. If there's anything specific, a specific matter you'd like to talk to me about, we can arrange a time for that on another day. Next slide, please. So, again, just the standard caveats that, I'm not going to be giving HR or legal advice, but I do think we can have a meaningful discussion, and that's really the purpose of the presentation today. It's not just to work through a series of slides. We could have emailed those to you in advance. It's to actually use the slides to facilitate a meaningful discussion. And again, any questions at any time, you can raise your hand however you want to bring up the question, and we'll get to you just as soon as we can. Next slide, please. So in terms of OAWP, we were originally established by a presidential executive order in April of 2017, and it was codified into law in June of 2017. And our functions are found at 38 U.S.C. 323. Our mission is to promote and improve accountability within the VA. All assistant secretaries across the VA are not created equal. Some are presidential appointees and Senate confirmees, others are not. And our assistant secretary is one of those folks who is both a presidential appointee and a Senate confirmee.
Okay. Okay. I am back with you now. All right, so what I've just provided for you was some issues resulting in OAWP failure to conduct investigations and failure to hold properly conduct investigations and failure to properly hold retaliators accountable that engage in retaliation. I can tell you that I have at my local facility, we have three confirmed whistleblower retaliation cases. And why I'm telling you that for this reason. The information that the independent, unbiased arbitrators found agency had violated in whistleblower retaliation was the exact same information that had been given to the Office of Accountability and Whistleblower Protection in 2020, and again in 2023, and again in 2024. They were given the exact same information. However, for some odd reason, OAWP could not find local agency officials hold them liable and accountable to whistleblower retaliation. Here is the difference. When the allegations were made to OAWP farmed it out to the local vision. When the allegations were given to an independent arbitrator, for some unknown reason, the people at the vision level, Abner Martinez, Patrick Shea, Jennifer Jenkins, the managers and the Vision 15 people who were writing reports to OAWP, none of them appeared to testify and explain their actions that were involved in drafting a report back to OAWP. For some reason, the managers were afraid to testify and come on and explain their part in the retaliation, their part in targeting the employee, and their part in the whistleblower retaliation. The managers refused to come on under oath and testify as to their involvement. That's the difference between an independent arbitrator and OAWP. OAWP was taking the manager's word for the gospel and closing out whistleblower retaliation cases, working in connection with the local vision. When they appeared before an independent, unbiased arbitrator, when the issues were presented to a independent arbitrators have found them liable for whistleblower retaliation on 2 individual separate occasions involving 2 individual separate disclosures. That is why it is my opinion there is not a reason to have an Office of Accountability and Whistleblower Protection Office. Why? Because an independent arbitrator can do the same thing that a OAWP investigator should be doing and do it from an unbiased perspective. What you heard was Eric Calhoun say OAWP was biased against employees. You've never heard that from one of the arbitrators that found the agency liable for whistleblower retaliation. And for that reason, it is my opinion that OAWP is a waste of taxpayer money. It is a waste of taxpayer funds. It is a complete waste of money for that money to be spent funding the OAWP office. Okay? Now, I always finish with giving you my contact information. My name is Kevin Ellis, Kevinellis. Once again, my phone number 573-429-9030. Let me give you my email address. I'm going to give you 2 email addresses. One of them is my government email address, which is kevin.ellis@va.gov, KEVIN.ELLIS at va.gov. Then my personal email address is kce40@yahoo.com. And I work from my personal email address quite a bit because I've been diagnosed with anxiety and depression related from the agency's whistleblower retaliation and anti-union unanimous charges against me. So I'm on medical, I'm receiving medical care right now as a result of what the agency has done. Now, I want you to understand the story that you heard me tell today. I can assure you there are thousands of more stories like that all over the country. I know that for a fact because we have about 5 more employees in my facility in which the same thing has occurred with. They made reports of OAWP. The complaints were hung out there starting in 2018 with Sonia Ellis, was finally closed out in 2022, 2021, 22 timeframe without an explanation, just closed. This is happening all over the country. If you have filed a whistleblower complaint and it has been closed and agency officials were not held accountable and you believe that your complaint was unjustly closed and not properly investigated and people were not held accountable, I'm asking you to contact me at the numbers or the information I gave you. Cell phone number, contact me by email address, however you want to do it. I'm open to having a conversation with you because we need to collectively, as whistleblowers throughout the country and throughout the Department of Veteran Affairs, we need to address the injustice of the Accountability Office, not doing the proper investigations, and not holding agency officials accountable. Once again, my name is Kevin Ellis. God bless you, and I'll speak with you later.